following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the latest developments in the field of alternate dispute resolution in Sri Lanka. Has the landscape for arbitration grown to be more conducive to change, or are we still behind on international standards? A very good evening, and thank you for taking the time to join us on yet another episode of Law, Land and Liberty, where we bring to you key legal topics and break it down for the layman. Now, tonight's topic is something that we have briefly touched on very shallowly in the past on a surface level, and that's on arbitration in Sri Lanka. And to talk about this very intricate topic, we have with us someone that is very well suited for this topic, and that is Mr. Hiran Alwis, attorney at law. So thank you very much for taking the time to come on to our studios today and actually explain this topic to our viewers here tonight. A little bit of an introduction into Mr. Alwis. He is a senior legal counsel with expertise in the area of arbitration. He's also the chairman of the Sri Lanka National Arbitration Centre, among many other accolades as well in this field. So before we get into the topic, here is a little bit of a breakdown on how we're going to approach today's discussion. First, we'll be talking about a bit of a general overview on arbitration and its key pieces of legislature. Next, we'll be getting into practicalities and also recent updates that we have seen in the current sphere. And finally, we'll be talking about international standards and the future outlook of arbitration in Sri Lanka.
Hello, my name is Pansilu and I'm working as an international relations officer. My question is on practicalities. What are the biggest obstacles faced by alternative dispute resolution process in Sri Lanka?
All right, well, we have a lot to cover in tonight's discussion, so let's get right to it. So once again, thank you very much. We have quite a bit to unpack when it comes to this area as well, and a lot of technicalities to discuss, also how it has evolved in the recent spheres. But before we get into any of those specifics, I think it's important for us to really focus on the basics. If you could just start us off in this discussion with explaining to us the current legal framework that we have in place for arbitration and how we have seen it evolve over our history.
Yes, thank you Anuradhi for inviting me. Well, the arbitration really has a long history in Sri Lanka. There was previously an arbitration ordinance, so that was in existence for over 100 years, which is not very well known. So in 1995, new legislation was brought in. So now the arbitration is governed by the Arbitration Act, number 11 of 1995. So that is, in answer to your question, the principal statutory framework that governs arbitrations. It is based on an international treaty, what is called the New York Convention. So the preamble to this statute refers to that. So our law basically is in conformity to international standards, and based upon that, arbitration is conducted. There is a specific high court that is set up for enforcement of arbitration awards, with a limited right of appeal to the Supreme Court. So that is basically the outline of the present law.
So historically, we have seen that it has come up with international standards, with sort of references to international pieces of legislature and statutes. If you could explain the role of, earlier you mentioned the Arbitration Act as well, preceding or following the arbitration ordinance of 100 years. If you could specify the role that the Arbitration Act plays when it comes to dispute resolution in Sri Lanka.
Yes, so that is in fact the crux of this whole topic. Arbitration per se is a method, consensual, contractual method where parties use to resolve their disputes. So it is fully recognized in law, locally and internationally. So there has to be two parties to a contract who agree to resolve their disputes in a particular manner. So if they say they are willing to resolve their disputes by arbitration, those disputes would be referred to arbitration and not to courts. If one of the parties go to courts and the other party objects, then the courts have no jurisdiction. So this is basically, as a British judge called, it's private sector dispute resolution. Internationally recognized, as I said, based on treaties, and even for domestic contractual matters, which parties agree to resolve their disputes by arbitration. It has to be done by arbitration, and it can be done and enforced like a judgment in a court of law. That is the pith and substance of the whole regime of arbitration.
So we need to understand that decisions made through arbitration are not of a lesser degree, and it has been upheld and recognized in a court of law as well.
Yes, that is also important, because there is a misconception whether this is something like a mediation or a voluntary mediation. It is not. Arbitration is another method recognized to resolve disputes. So it is somewhat of a court hierarchical system which is outside the system. Parties sometimes say it's a more democratic system, in the sense parties decide how to resolve their disputes by an arbitrator selected by the two parties, the law which they select to govern them, and sometimes the rules which they select. So once you agree to that mechanism, you are fully bound by it. So there are reasons which parties go for this modality. So that is, I mean, that's a topic, that's a very vast topic in itself.
Exactly. There is quite a few areas that I feel like we won't be able to touch on because of the limitations of the time. But moving on into the crux of our discussion, if you could explain to us, you mentioned mediation, so there are other forms of alternate dispute resolution as well. Could you specify to us how specifically arbitration differs to other arms of alternate dispute resolutions, like mediation, as you mentioned previously, or conciliation?
Yes. So very briefly, Sri Lanka has a very long history of dispute resolution in various fields. I mean, people talk about Buddhism. If you delve into philosophy, they say how the village elder or the temple, got involved to resolving disputes. So that is a purely voluntary mechanism. So with that history, we have come to a situation where there is mediation which is through statute encouraged. For example, disputes below a certain value of money prior to going to courts is sent to mediation for voluntary discussion and settlement, which is a good thing. And then thereafter only they come to courts. But there is no binding nature. So now there is also a move to get some statutorily recognized mediation settlements which can be enforced. So that is a methodology that goes by itself. The court system, which everybody is fully aware of, so there are various things. For example, fundamental rights. You go to the Supreme Court. You can't arbitrate those things. Then criminal matters, you go to the courts. There is no arbitration for those. So there are certain areas of the law which arbitration does not, is not governed by arbitration. So that is, for example, matrimonial matters, it can't go for arbitration. So there is a policy behind the law. So arbitration per se, the act says, any dispute or agreement, contractual or otherwise, which parties agree to resolve by arbitration, can be determined by arbitration. Except what is called public policy, where, for example, criminal law, if parties say we want to resolve these disputes, that will be struck down by a court. So generally it's commercial, contractual and international trade that is governed by arbitration. So just to digress slightly, international trade, we are trying to export and import and develop that field strongly for our economy. 99% is governed by arbitration. So knowledge of this is vital for our entrepreneurs.
Exactly, and for the growth of our economy as well, we need more individuals that are better versed in international trade, specifically when it comes to the legal processes of arbitration relating to international trade as well. I think we do need to get to the specific areas of arbitration that we see in play in Sri Lanka. But before we do, I'd like to divert our attention to the practicalities aspect of arbitration, the practical challenges that we see. If you could, sir, explain to our audience relating to the common challenges and obstacles that we see, that we face when it comes to arbitration in Sri Lanka.
Yes, so one of the challenges which we have is always, we say we have all the laws in this country, but effective enforcement of the existing laws is the problem we are having. So I am not a proponent who supports the view that says there is laws delays. In my opinion, humbly, I say there is no laws delays. What we have is non-implementation of the existing laws. So to answer your question is linked to that point. In my view, now we have all the laws, as I said in the opening remarks. Then what happens really is effective enforcement of these decisions. So there is now a high court specifically set up to enforce arbitration awards, because once an arbitration decision is given, if a party does not honor it, you can go straight to the high court and register that award, and after a preliminary hearing can ask the judge to give a judgment and a decree according to the award. So there is no trial. So that is why I say arbitration is very well recognized, and you can get a judgment without a trial. Now the practicality is once you get a judgment, there is you need to enforce that, or to make it tangible, or what they call in legal terms fruits of the decree. So one of the problems which we are having is because of the volume of the arbitration coming into one particular judge, it is humanly impossible to handle all that traffic. So whilst we were thankful that a special court was set up, that also I was involved in the discussion with the then Bar Association Chief, Mr. Shibliasis, and I believe the minister was Mr. Rauf Hakim, and they understood this concept and established this court, which was a very good thing. But because at that time there was a high court that was handling criminal matters, that judge with all his work had to come and sit into the enforcement case and handle them. So there was a backlog there. So then this specific court was set up. But this present court also has to handle other commercial matters as well, apart from this. So I believe we need simply more infrastructure. That means more courts, more judges, more staff to enforce this mechanism. For example, if you say, so that is one of the practical problems which we are having. For example, if a party comes and says they want an interpreter, that court must have an interpreter readily available. Now for various reasons, maybe lack of staff, lack of financial support because of this crisis, that is not there. Then if you get an award, to enforce it, you need the decree mechanism and enforcement where the fiscals go, etc., etc. So that also the court staff has to be available. So that is another area, that is really a critical area, which is, there is a bottleneck there in enforcing. So whereas a party, individual party, they are not interested in all these excuses. They want, if there is a judgment or award in their favor, to get it realized as quickly as possible. So that is one practical reason. I believe this has to be strongly addressed to by the state. Secondly, a party rightly has a right of appeal to the Supreme Court on very limited grounds. So you have to get leave to the Supreme Court, and if leave is granted on a substantial question of law, then that is set for hearing. Now again, a practical problem arises. We have that limited number of judges in the Supreme Court, with all the work coming from all the courts. Then arbitration matter is just one of those. So leave to be granted, you have to fix it for support time in, it might take about 3 to 6 months. If leave is granted in the Supreme Court, it is fixed for hearing. That hearing may be 1 year down the line, because there are already cases already fixed.
There's a backlog.
There is a backlog of cases already fixed, so there is no way of prominence being given to these cases. So when it comes for argument, then there is hearings. Both parties have to be heard, submissions and an order. So then with judges with their massive workload, it finds it impossible to give only attention to this. For example, in the Supreme Court, there may be in one particular bench 25 cases set out. So that is in fact another practical problem. So you have to come with some infrastructural mechanism through the state to alleviate these delays. So on that point, I think it's very vital for the state also to expedite and help in this process, because for example, countries like Singapore and Malaysia, states gets involved because there has been a huge benefit for the country, economic-wise, by expediting this, and then they market it. For example, Singapore markets the fact that they have a specialized high court for enforcement of arbitral awards in their ease of business rankings and other promotional material. They do that. So I think we have to get that sorted out there. Thirdly is there is tardiness within the system. So in my opinion, 80% of the arbitrations are going fine, but about 20% is a matter of concern. So unnecessary delays. For example, parties don't know whom they appoint as arbitrators or whom the advisors they want to get. So then they get bogged down in unnecessary details, and there is so for that our system is also to blame. So that I think some attitudinal changes is necessary, because this is thinking where you delay and go is not the way to go forward. I think we have to go faster and make the system more efficient, then people will benefit. So I think now with the stabilization of our economy, thankfully, and with new and fresh thinking coming, and with, as I say, fresh thinking and modern thinking, I hope we can push this forward.
I want to touch on the what you just mentioned relating to the trained arbitrators and basically personnel shortage that we see as well. Maybe it could relate to the fact that we have other crises to divert our attention to as a country, but we really have seen quite a lapse in that area when it comes to manpower and also infrastructural, just not up to standard when it comes to quantity and also quality. So we do have to touch on that. But before we get into the other specifics on practical challenges and obstacles, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back after this.
Hello, my name is Haimi Jayawardena and I'm a development practitioner in profession. My question is on the future. Does Sri Lanka's arbitration adequately meet international standards, or is there more to improve moving forward?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Hiran, the Alwis attorney at law. We were just talking about the specifics and the general overview of arbitration and the legislature surrounding arbitration, and we just left off on a very important point, which is the practical challenges that we see when it comes to implementing arbitration effectively in Sri Lanka. So you mentioned a very important point relating to how 80% of, roughly 80% of arbitration cases are being handled out in a very smooth manner, but the issue is when there are unnecessary delays. For example, there's bog downs in the infrastructure, or when it comes to appointing arbitrators and other personnel. If you could talk to us about if you have any ideas on how we can move to streamline this process better, specifically what you mentioned with modern thinking and also new strategies that we can implement in Sri Lanka.
Yes. So one of the things is lack of awareness. So in this role also, now in the organization SLNAC, I'm involved as chairman. We do this voluntary. It's a not-for-profit organization. So we have various other component for trade chambers, professional bodies who are all here. So one of the mandates is create awareness. So that's why we are thankful to you for having us here. So lots of people don't realize the basic things. So arbitration clause per se in legal parlance is called the midnight clause, because parties negotiate a deal, enter into a contract, last moment they decide or they realize there is a dispute resolution clause that has to be put in. Then so it's midnight, they look at something, invariably it's a cut and paste, as they say. So 5 years down the line, when a problem arises only, they will realize. So for example, there are hilarious clauses. They say arbitration to be held in Colombo, New York, or the law of Wales, but the hearing is in Sri Lanka. So I can't mention specific entities. Some very well known entities have got into this. So then there were two young boys, I always say, who developed a software package. This was about 15 years ago from, I think, Moratua. They did everything online. Unfortunately, they got the dispute resolution clauses online. They never got paid for their work, which they exported. Then they got some advice, and we looked at the contract. It says law of Delaware, USA. So these two boys couldn't even buy a air ticket. So I don't know what happened to their claim. So lack of knowledge and awareness. So that is important. We always say it's worth to get some advice, if you can, prior to signing any contract. That is, I must touch with, that's a very bad habit in our country. Apart from arbitration also, parties are getting into contracts without reading the fine print. You know, whether it's from banking to whatever the field. So that is something, so arbitration, you should get some specific knowledge. Secondly, once the process starts, you should be savvy enough to see whom you want as your arbitrators. There are people who are qualified in the field, some who are experienced practitioners, experienced judges, etc. So you have to make sure that you are properly advised upfront. As the saying goes, not that I'm trying to promote lawyers, more lawyers at the beginning means less lawyers at the end. So otherwise you'll get caught into a long process trying to find out how to start an arbitration, as you correctly pointed out. Now that we have found out recently is also another cause for delay, because one party sometimes avoids appointing an arbitrator. Then you have to go to the High Court and make an application. So that judge with all his work has to give his mind to this, write a decision on that. So that can take another 6 months. So we have found some people purposely doing this to buy another 6 months' time. So it's one is, so as I said, awareness. Secondly, I think attitudinal change is also necessary, including the people in the field, to realize delay is not the way to go. But for example, I always say there is inherent delay in a legal system because you have to hear both parties. You can't hear only one party. So the Act very wisely says inordinate delay. So if there is inordinate delay, the arbitrators and the court should crack down on it.
We need to see specifically that there are streamlines in areas where we can actually cut down on the time and not maliciously, in some instances, try to pull for extra time using the loopholes in the system that we already have in place. So moving on from the practical obstacles and the practical issues we see, I think recent updates, we've seen quite a lot of conversation relating to arbitration recently as well. We've seen it come up with Port City, and also with our economic development, we see a lot of international influence and a lot of international communication going both ways. And you mentioned how essential arbitration can be for international trade. If you could explain to us if there have been any recent updates relating to the legislature of arbitration. Have there been amendments? And if so, are there any key highlights that you'd like to point out?
Yes, so as the Act came in 1995, by and large the Act is good because it's based on the model law, but because of modernization and various demands for expediting certain sections, various committees have been formed at certain points. So there was a ministerial subcommittee formed for upgrading the arbitration laws. I was also invited to be in it. So we had deliberations for about 7-8 months. Judges, other practitioners, some academics. The report was prepared. Unfortunately, it was not presented to Parliament. So I believe it's with the legal draftsman's department. So we focused on some critical areas which we can cover the gaps. One is cutting short the time between the arbitrations and the High Court enforcement, and being very strict on the time limit. Secondly, within the system of arbitration, where the arbitrators have been given more power to enforce the awards, for example, in relation to time procedural orders. Thirdly, but there was a slight lacuna in what is called interim reliefs in relation to arbitration. So where it strengthens the mechanism for the arbitration tribunal to give an interim order if it's necessary, and for the High Court to strongly enforce that. So those are three areas which I can offer and say. And there was a comprehensive study, so I would like to urge that those proposals be tabled, because that's a bipartisan effort. There is no political bias in that, and it's good for the country, and we can mark up that. And we are pushing this because not only in a legal sense of benefiting the economy and the entrepreneurs, it is also a financial opportunity. Our service sector can be really boosted by this mechanism. I was at a conference in Hong Kong about a month ago. We signed an agreement with the Hong Kong party in relation to arbitration. So the chairman there told me Hong Kong is handling $12 billion worth of disputes per year. So Sri Lanka should at least have some part of that pie, and everybody will benefit. Not only legal professionals, other professionals from engineers, quantity surveyors, architects, and if there is more and more traffic in that area here, ancillary things like tourism, image of the country, cross-border trade, all will benefit.
We have had, of course, this dream almost for Sri Lanka to be to have some sort of commercial capital that can hold its weight against other heavyweights like Singapore and Hong Kong, but we haven't really seen that come to play despite even the construction of Port City. It's quite a slow progress, so arbitration could be the key for our all our infrastructure and also our industries to benefit from, especially on an international scale, if I'm understanding you correctly, sir.
Yes.
Moving on, specifically when it comes to the international standards that we have now, we did touch on it a little bit previously as well, and the fact that our base laws are based on an international framework that we have seen. Could you explain to us the framework that we already have in play? Does it comply completely with international standards, or where are the lacunas in this law that we have right now?
Yeah, good question. Whether it conforms completely. The answer is it conforms to international standards. Whether it conforms completely is the lacuna. So I think we have to look at international best practices and move the needle upwards. So one is these suggested amendments to the Act. Secondly, it's critical to get this infrastructural support from the state or whatever, because it is not an expense. It is actually an investment. So international, the law per se, as in lots of our laws, is there on the books. So that is some areas which we can look at. And secondly, the whole process has to operate under a, what you call, recognized mode. For example, any tardiness or unfairness or questions of impartiality have to be addressed very, very seriously, which we also as our board takes very seriously.
When you mentioned the previous reports, you mentioned the committee that was in charge of drafting suggested changes and also a better streamlined process for arbitration in Sri Lanka. You mentioned that it has been on hold for now and it's not really being implemented, or even the process has been on pause. Can we expect that to move forward, or have you had any sort of information or communication relating to actually implementing these changes?
Yes, unfortunately, once the report was prepared, as far as I know, it was sent to a legal draftsman department, but it's a process that goes through the ministries. So I think with the changeover of the governments and whatever reason, which I am not privy to, this got stalled. But unofficially, we have been trying to find out where is the bottleneck and trying to maybe go forward. I think it's very critical because that work has been done. We don't have to reinvent the wheel.
We just need to implement it.
We need to implement it, and we have to, I mean, we can't look at 100% solutions. If there's a 80% solution, we must take it forward. And I think we must strongly push these changes if you want to get our economy going. And these are new areas of even legal work for opening up for young professionals. So many talented young people are passing out from our universities and schools of study. So we must look at these new areas and implement them with all other laws. For example, our Electronic Transactions Act is as good as any in the world. But whether it's been utilized in all the areas is a matter of question. So I think we must focus on implementation of the existing laws, which I mentioned at the start.
When you mentioned about the young entrepreneurs and also young individuals that are passing out universities and hoping to actually have a stable foundation on which they can work on in the country, specifically when it comes to international relations and international communication, foreign investors, do you believe that our current arbitration laws adequately protect and also entice foreign investors to come and actually engage with our laws and engage with business in our country?
Yes, the law per se is very good, and we can frankly tell any investor, look at our laws, get advice, you have no problem with the laws. So if they do their deeper study, they'll know there is some infrastructural bottlenecks, which is the area which we have to address. But from my discussions, I mean last year where there is more interest in Sri Lanka than we expect. There's huge interest. So from within the region, out of the region, so there are people who have come and looked at Sri Lanka. So obviously they are looking at something positive in this country. So it's up to us to, correct our areas which we have to correct and take it forward. Because even not only the law, even they looked at some of the entrepreneurs who are coming out, the younger people. Women entrepreneurs are getting involved. And even some of our professionals who are coming out are as good as any in the world.
So we have positive reception. It's just that from internal aspects, we don't see much enthusiasm to receive that interest and to properly utilize it in order to turn it into something fruitful for our country and for our economy. When it comes to countries that have already successfully modernized their arbitration frameworks, and also about nations that are already very much secure in their methods of arbitration and their processes, like Singapore and Hong Kong, we do need to see if Sri Lanka has measures up to that, or if there are key lessons that we can learn from those countries specifically when it comes to arbitration. Before we speak on this specific area, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back right after this.
Hello, my name is Salman Halim and I am a digital marketer. My question is on legislation. What laws govern arbitration in Sri Lanka?
Welcome back to Law, Land and Liberty. We are in our final segment now in conversation with Mr. Hiran, the Alwis attorney at law. So thank you very much for the previous two segments. I believe we gave a lot of understanding and a good overview for our viewers to understand the opportunity that lies in arbitration, and also what key challenges that we face when it comes to Sri Lanka's laws and the implementation of them right now. We left off for the break with me explaining that we need to talk about the lessons that we can learn when it comes to the international standards that have been implemented in other nations that have already modernized their arbitration process. If you could explain to us, sir, the key areas that we can actually draw from countries like Singapore and Hong Kong when it comes to arbitration.
Yes, so really, this is a field that I had studied previously. I think to the National Law Conference House in about 2010, I gave a report on the potential, economically wise, and for the region to develop this as a arbitration hub, Colombo. Then during the course of my reading, I found out even late Justice Prasanna Jayawardena had specifically referred to the potential and said how Sri Lanka has lost out to Malaysia and Singapore in relation to this field in a big way. So that means we have, in common parlance said, missed the bus somewhat in this field, because as the Singapore law minister said at one point, this is a multi-million-dollar industry. So the state got involved in assisting this arbitration process, the centers or the personnel, because they knew that there would be a tangible benefit by having an efficient system. So what we can learn from them is for the state to give some support where it can. But the state should not interfere in the arbitral process, because arbitration is private sector dispute resolution, and if the message goes around that state is involved in the dispute resolution mechanism, it would not be good. So we have to be wise enough there, but the state also has to be a bit proactive and to see where they can assist in certain areas. So again, the infrastructural thing is where the state can really assist. Secondly is lack of awareness. So more seminars for the exporters, importers, students, professionals in the system. So that is one area. Thirdly is international best practices. Higher standards have to be maintained. So we have to ensure that reputation is kept and enhanced. And most importantly is the use of digitalization and electronic commerce platforms and all that. That is one area which these countries have moved forward, which we are lagging. So, and they're marketing that, for example, online hearings, digital documentation, electronic filing. So as I said, we have all the laws, we have not been able to implement these. So I think with this crisis is an opportunity where we have to leapfrog and join these countries, because part of our study is to look at the potential for this field even within this region. So as I said earlier, our laws are there in the statute. Then we, for example, our center promotes what is called the UNCITRAL, United Nations based rules, which parties can voluntarily adopt. So that's an internationally recognized set of rules. So we have everything here on paper, but effective implementation, even better late than never, I think we can do this. I always take the analogy of cricket. We became the cricket champions in 1996, but we had been playing cricket for over 100 years before that. So lots of people contributed to the growth of cricket who were unheralded, but became world champions, and now cricket has become a $1 million business in this country. Same way we can look at our service exports and professionals to generate that income for the country, and arbitration is one of it.
Exactly. When it comes to international opportunity as well, we see that it's much more vast of a field when compared to other areas. When it comes to arbitration, how we can actually facilitate for other countries as being an arbitrator or an international arbitration hub. Do you believe that we have this as a foreseeable possibility in our future, sir, or are we still too far off?
Definitely there's a possibility. There is a lot of interest in Sri Lanka as a neutral venue because of our location, then our knowledge of our professionals, our English language skills, and our laws to a great extent based on English commercial law background. So if you look at where we are situated, we are on the east-west route of shipping. Then our maritime boundaries is 3 times our land size. Thirdly, we are on the doorstep of 1.5 billion market, India, Pakistan, Bangladesh. There is inter-regional trade. Southeast Asia is this there. So there is huge potential, in my opinion, for developing Colombo as a neutral and international arbitration site. For example, between India and Pakistan, there is definitely trade, but they may want to resolve their disputes within the region. Why go to London, Paris and New York? Come to Colombo. Even if there is no direct benefit, the country will benefit. For example, if there is a hearing in Colombo for international arbitration, from the hotels to the staff to the tourist drivers, taximen, all will benefit. So definitely, in my opinion, there is lot of scope. And this is not only my opinion, the foreign professionals and entrepreneurs have been telling that Sri Lanka has this potential. So it's a question of strategizing this and marketing this efficiently.
And sir, before we come to the conclusion of this program, we do need to talk about the future outlook a little bit more relating to the digitization efforts as well. But before we do, I'd like to pick up on a subject that we weren't able to touch on just as much when it comes to the neutrality aspect that you mentioned, that we can be a neutral venue, and the impartiality. Is Sri Lanka well on board with best practices? when it comes to implementing this neutral environment for arbitration, or do we see that there is still much to be taught for the arbitrators to understand true neutrality?
Yes, there are two aspects. So if it's a neutral venue, I think we have all the attributes. For example, if it's two outside parties who want a venue in Sri Lanka, who want logistical support or who wants arbitrators, there is definitely good potential. In relation to impartiality of decision making, my experience is by and large it has been good, but that is not enough. We have to make sure that the strongest possible standards are maintained. So to govern that, there has to be some international best practices and rules that are to be brought in. For example, unnecessary delays should not be tolerated at all. There has to be some stringent decisions in relation to that has to be taken, because as I said, because of 20%, a bad name is given to the balance 80%. But generally speaking, we have that attributes, and Sri Lanka and the Sri Lankan, our center and other centers have generally had a very good reputation in relation to impartiality and independence.
When it comes to the enforcement, sir, now of course it will take some time before enforcement happens because of our current system and the flaws in it. But once enforcement occurs, the arbitral awards that we have, once there is an enforcement, do we see an effectiveness there? Is it just as firm as we expect it to, or is there some sort of flexibility that has snuck its way in?
So that is I think the crux of the problem, really. Once you get an award, so you have to realize that in tangible form. So you have to go and seize an asset. So that mechanism is taking a long time. Some parties can move their assets here and there. So we must have a faster method where once there is a proper hearing and once you get a dispute resolved, that arbitration decisions are honored. In fact, I think there should be a mechanism where parties are blacklisted when an arbitration award is not honored. Secondly, for even a foreign party, our Act provides a foreign arbitration to be enforced in Sri Lanka. For example, let's assume there's a dispute in China and let's say Japan, and they find that company has an asset only in Colombo, for example. The Arbitration Act allows for you to come to the High Court, make an application and seize that asset. So for that you must have a very smooth and efficient system of effectively seizing those assets. That I think is a practical problem we are having, not only in relation to arbitration but general the court mechanism. So as people say, you realize the fruits of the decree, otherwise there is no purpose for people. All this legalistic talk otherwise will become useless. So that is one area which I think we have to really focus on.
That's one of our biggest issues. The weight that we give to an arbitral award needs to be recognized and it needs to be enforced as seen in the law specifically. Before we come to the conclusions, when it comes to arbitration in specific sectors, do we have a proper functioning network of industry-specific arbitration mechanisms in Sri Lanka specifically? So when it comes to the construction, trade and also maritime aspects, do we see an effective network?
Yes, so in certain areas, yes. For example, let's say financial services, construction area, Sri Lanka has a system in place. For example, even prior to arbitration, there is an adjudication system for construction matters. So that there are adjudication boards, there are people versed in that is going through. Financial sectors also, there are people who are knowledgeable and who know how to handle those matters. One area which I think we can focus on the future is the maritime area. Sri Lanka is an island nation. We have this sea area. Being with that resource, I think the development of maritime arbitration is a huge area which we have to focus on in the future. So that is possibly one area which mind has to be given to.
We do need to look at the development of maritime. Do we see a good foundation at the moment?
I think we have the foundation, we have the laws.
We just don't have the practical
We have not been able to realize that the benefits of that. For example, even the exclusive economic zone, which the government and even the others are all talking about, 3 times our land mass. So all these are discussions. So with that, with our ports and maritime knowledge, we must have our professionals also embarking on their expertise overseas.
So before we conclude these discussions, the future that we see for Sri Lanka when it comes to arbitration, you mentioned that we have potential. Is there something that you'd like to acknowledge, maybe enlighten our viewers on, relating to how we can contribute on an individual level to the furthering of our current legal landscape when it comes to arbitration?
Yeah. Effective enforcement of the existing laws. That is the theme I would like to say. So, as a first step, if we do within the law what can be done, expediting, eliminating inordinate delays, having proper knowledge, definitely there is potential, and I think with the present situation, we will be compelled to go ahead with some reforms. So better late than never. There is a lot of opportunity definitely in this field, and I think we have to strongly push the levers where it's concerned to get this service industry going, so that not only the legal professionals, other professionals, plus the industry, for exporters, this is of critical importance. Importers should have knowledge of this, banks should have knowledge of this. So overall, I think there will be a huge tangible benefit for the professionals and the country as a whole. So I think definitely there is scope and opportunity. We have to seize the moment.
We have to definitely seize the moment. I feel like that's the perfect way for us to end off this discussion on a hopeful note, that we have the foundation, we just need the proper implementation and the expediting of processes apart from inordinate delays, so that we can actually see Sri Lanka's arbitration network reach its full intended potential as a heavyweight in this region and maybe even in the future globally. Thank you very much, sir, for taking the time to speak to us today. Unfortunately, that's all the time we have for you here today. Thanks once again for enlightening our viewers on this very intricate aspect of arbitration. Thank you.
Thank you for having us.
All right, well, we'll leave you tonight with the words of English historian Herbert Reed. I can imagine no society which does not embody some method of arbitration. Well, that's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherthanerenglish. Thank you very much for watching. Have a great night.